Let me now turn it over to our hosts for today. This is Courtney and Sean over from GRS Community Management. Take it away, ladies.
Thank you, Jeff. Hi, good afternoon, everyone. My name is Courtney Buchanan, and this is Sean Thompson. We're both corporate trainers over at GRS Community Management. Our offices are located in Lake Worth, and we have a new office in Broward and Jupiter, and an office on the West Coast as well. We've been providing great, reliable service since 1989, helping community associations with everything under the sun. So if you're happy with your community association, we love that for you. But if they're not, definitely check our website out at grsmgt.com. So today's class is just for HOA board members. So we're really happy to have partnered with K. Bender Rembaum. We thank them for providing this class for everybody today. We just like I said, if you're happy with your management services, great. Same with your attorney, but if you're not, definitely check out K. Bender Rembaum's website, kbrlegal.com. They have so many resources out there for board members and community association managers. They do most education for board members I've ever seen any attorneys do. So we definitely appreciate everything that they do. And I love working with Kirsten. We've done a couple of these before. She's in their Tampa location. So big thank you to Kirsten for today's presentation. So with that being said, Sean, did you have anything you wanted to add?
Just please reach out to us at grsmgt.com.
Yep, that's where you can find us and contact us if you have any questions or you just want to get a feel for what we do over at GRS. So with that being said, we'll turn it over to Kirsten.
Thanks so much, ladies. Hello, everyone. I'm Kirsten Hensa, and I'm a partner and managing attorney of the West Coast office for the firm. For those of you who are not familiar with K. Bender Rembaum, we are an exclusive community association law firm, which means that we exclusively represent your condominium, HOA, and cooperative associations throughout the state of Florida. As Jeff and Courtney may have mentioned, we do have multiple office locations throughout the state, with our main office being in South Florida, in Pompano Beach. We also have offices in Palm Beach area, in the Orlando area, and then, of course, I manage here the West Coast office, which is in Tampa. So I've been practicing law going on 18 years, and I've been with the firm since 2010, so quite some time. All right, so we're going to go ahead and jump into our webinar today. Let me go ahead and share the slides.
Okay, while Kirsten's doing that, I want to mention some of you might have come on late, like Rebecca B is saying sound is poor. Rebecca, I see you're on here with two different devices. I'm going to repeat to anybody who came in late. If you are here with two devices, disable the audio on one of those devices. That's why you're getting echo and feedback, because you are hearing us on two different devices that are close together. Back to you, Kirsten.
Awesome, thank you. Can you see the slides, Jeff?
Perfect, yes.
Okay. Beautiful. All right. So the class today is going to focus on HOA meetings. So meetings with regards to those homeowners associations that are governed under Chapter 720 of the Florida statute. I'm not going to be discussing anything relevant to the condominium statute, which is Chapter 718 of the Florida statute. Okay. So with that said, Okay. Okay. With that said, let's start with why you're here. You're here because you have an obligation to take certain classes throughout the year to fulfill your continuing education requirements. Now, the amount of hours that you have to fulfill will depend on the size of your community. Okay, so if you live in a community that has less than 2,500 parcels, You have 4 hours of continuing education credits to fulfill annually. And if you're in a community with at least 2,500 parcels or more, then you have 8 hours of continuing education to fulfill, okay, which is why you're here. All right, let's start with membership meetings. So when I talk about membership meetings, I'm talking about meetings at which members, which are typically record title owners of homes within the community, and those are meetings at which only members get to vote, not the board, but the members. As you may be aware, certainly the board of directors has authority to conduct business, association business, and vote on most things related to your association and community. There are, however, specific actions that require membership approval, and those would be either set forth in Chapter 7 of the Florida statute or in your governing documents. So when we talk about membership meetings, we're talking about meetings at which owners get to vote. Now, under the umbrella of what a membership meeting is, there are two types of membership meetings, okay? There's your annual meeting, okay? And then there are special membership meetings. So annual meeting, if nothing else, that is the one meeting that you're going to have a year, and it is typically the meeting at which you have your election, okay? That's your annual meeting. Any other meeting throughout the year, other than your annual meeting, will be called a special membership meeting, okay? And they may have different notice requirements. So with regard to your annual membership meeting, the association must hold a meeting of its members annually on the date, time, and location set forth and in accordance with your association bylaws. So you're going to have to look specifically to your bylaws to determine on what date, at what time, and at what specific location you have to conduct your annual meeting. And you may have bylaws that specifically say your annual meeting has to be conducted, on the third Thursday of the month in March. Okay, you may have something more general, such as a provision that we would recommend for you to include in your bylaws that would say, the board may hold the annual meeting on such date, time, and location as determined by the board. This gives you, the board, some flexibility in determining when to set your annual meeting. Okay. Now, election of directors must be held in conjunction with your annual meeting. Now, for special membership meetings, as I mentioned, special membership meetings refer to membership meetings other than your annual meeting. So, for example, you might have amendments to your governing documents that you might be looking for owners to approve. Typically, unless you present those amendments at the annual meeting, you can do so at any special membership meeting throughout the year and have owners formally approve those amendments at that meeting. You may have other specific issues that you might need the members to vote on. And so you're not limited to getting a membership vote only at your annual meeting. Now, when can special membership meetings be held? Well, typically it's either when called by the board or when at least 10% of the total voting interest of the association petition the board to conduct such meeting, unless you have a different percentage set forth in the bylaws. So yes, this means that the owners have the ability to force the board to call a special membership meeting on any particular issue that owners have a right to vote on. Okay, so unless your documents provide for a different percentage, all you would need to receive is a petition from 10% of the voting interest. All right, agendas. For the annual membership meeting, unless your governing documents require otherwise, notice of the annual meeting does not need to include an agenda or description or purpose of the meeting. However, as with any meeting notice, we would encourage you to include an agenda for all meetings. Now, for special membership meetings, notice of the special meeting must include a description of the purpose or purpose for which the meeting will be called. So you need to include specific agenda items for special membership meetings. And then business conducted at a special meeting is limited only for the purpose described in the notice. Okay, that goes with any other meetings that we'll discuss later on, such as board meetings. All right, notice requirements. All notices must provide the date, the time, and the location of the meeting. And if the bylaws do not provide for giving notice to members, then the association must either mail, deliver, or electronically transmit notices to all owners no less than 14 days before the meeting. So again, you're going to have to look at your bylaws to see what notice requirements are set forth in your bylaws for both annual and special membership meetings. And you might have same notice requirements for both, or you might have different notice requirements. Either way, the bylaws is the source that you need to go to first. If your bylaws are silent on the date on the notice requirements, then the statute says you have to provide owners at least 14-day notice. And that notice, again, can be mailed, can be hand delivered, or can be electronically transmitted, which includes by email to those owners who have consented to receiving notices electronically. Okay. Now, the statute does provide that evidence of compliance with this 14-day notice requirement has to be done by affidavit, which has to be executed by the person providing the notice and must be kept as part of the official records. So typically, it'll either be the secretary of your board or your property manager that will provide the notice. So they're the ones that will have to execute this affidavit, which will keep as part of the official records. Now, notice must be mailed or delivered to the address identified as the owner's mailing address in the official records, or it can be electronically transmitted if the owner has consented in writing to receiving notices electronically. Now, electronic notice requirements. The association may provide notice of any meeting by electronic transmission, which can include email or fax to any member who has consented in writing to receiving notices electronically and has provided either an email or a fax number. Now, the email address and fax numbers provided by the members to receive notice electronically must be removed from association records if that member later revokes consent to receiving notices electronically. However, the association is not liable for any erroneous disclosure of the email address or fax number for receiving electronic notices. Also, electronic transmission may not be used as a method for giving notice in connection with special meetings for purposes of recalling directors. Okay, additional notice requirements. We're still with membership meetings. So in addition to sending notices to members, oops. Did I just stop sharing?
I can still see it.
Oh, you can still see it. I think I just. Okay, here we go. Sorry about that. So in addition to sending notices to the members, the association may also adopt reasonable procedures for posting and repeatedly broadcasting notice and agenda of the meeting on a closed circuit cable television system serving the association. So this is an alternative notice option for those communities that may have a bulk cable contract. And so if you have this option of closed circuit cable television system, then this could be a viable option for you. Now, website posting requirements, just as a reminder, as of January 1st of 2025, those associations with 100 or more parcels are required to have a website, and you now must post notice and agenda of membership meetings on that website at least 14 days prior to the meeting. The notice has to be posted in plain view on the homepage of the website or a separate subpage for the website labeled notices. And then in addition to posting the notice, you also have the obligation to post any document that is associated with that membership meeting. And that document has to be posted at least 7 days prior to the meeting. So, for example, if you're having owners vote on proposed amendments to your governing documents, then those proposed amendments would have to be posted on the website along with the meeting notice. All right, members' right to participate at membership meetings. Well, as many of you are aware, owners have the right to attend all membership meetings as well as to speak at those meetings with reference to either any item that is open for discussion, and then certainly any item that's included on the agenda of that meeting. Now, notwithstanding anything to the contrary that may have been provided in your governing documents, owners have the right to speak on these items for at least 3 minutes. Now, that said, the association does have the right under the statute to adopt reasonable rules governing the frequency, the duration, and other manner of owner statements. And then also note that membership meetings must also be held at a location accessible to physically handicapped persons if it is requested by the physically handicapped person who has the right to attend the meeting. And then owners also have the right to tape record or videotape membership meetings. But the board also has the ability to adopt rules governing the taping of meetings. Okay, so you can, for example, adopt a rule that requires owners to let the board know in advance of the meeting that they will be taping or video recording it. All right, quorum and decisions of the members. So unless there's a lower number provided in your bylaws, quorum for the minimum quorum requirement for membership meetings is 30% of the total voting interest. So you'll have to take a look at your bylaws to confirm what your quorum requirement is. And if you have a lower percentage, then you'll defer to that lower percentage. So I've seen, quorum set at 20%, 15%, 10%. If you have nothing lower than 30%, or if your documents are silent, or in some cases, if your bylaws provide for a greater percentage, then you will default to what the statute currently provides, which is 30%. Now, unless otherwise provided in your governing documents, decisions that require vote of the owners must be made by the concurrence of at least a majority of the voting interest present in person or by proxy at a meeting. So what that means is it's not a majority of all the voting interest. So if you, for example, have a community of 100 parcels, and let's say a quorum for your community is 30% of those 100, okay, a vote of a majority of the voting interest present means a majority of, presuming the minimum amount of owners that are present at the meeting is 30%, you would need a majority of the 30% to approve the action. Unless, of course, your governing documents require a different voting requirement. So, for example, if you're looking to, again, we're going to go with this example of amending your governing documents. If, let's say, you want to amend your declaration, and your declaration requires you to get the approval of 75% of your membership in order to pass an amendment. So what that means is you're going to have your membership meeting. You're going to first establish quorum. So you have to have at least 30% of the owners present at that meeting in order for you to even proceed with the meeting, unless, of course, your documents have a lower quorum requirement. And then once you've established quorum, then in order to pass the amendment to the declaration based on this example, you would still need to get the approval of 75% of all the owners. Okay. Let's move on. All right, proxies. So unless otherwise provided in the statute or in your governing documents, members have the right to vote in person or by proxy. For a proxy to be valid, it has to be dated, include a date, time, and location of the meeting for which it was given, and it has to be signed by the authorized person, typically the record title owner or perhaps an individual with a power of attorney. The proxy is only good for the specific meeting for which it was originally given. Okay. And any lawful adjournment of the meeting. However, the proxy expires within 90 days from the date of the original meeting. So what that means is you have the option at membership meetings to recess and reconvene that meeting for as many times as you need to get that membership vote that you need within that 90-day time frame from the original date of the meeting. So, the procedure for recessing and reconvening typically requires a motion from the floor to recess and reconvene the meeting for a specific date and time, as long as it's within that 90-day parameter. And then once you have a second and a majority of the owners present approve the motion, then the meeting can be reconvened. Okay, and you can do this as many times as necessary to get the vote that you need. But on the 90th day of that meeting, once if you haven't received yet the necessary votes, then essentially the issue dies. You adjourn the meeting, and then you would have to start the process again because that proxy is no longer valid beyond this 90-day time frame. Now, proxies are revocable at any time by the person who executes it. And then any proxy holder may appoint in writing a substitute proxy holder to act on his or her place if the proxy provides the right to do so. And a copy of the original proxy can be used if it is a complete reproduction of the entire proxy. So, while original proxies are certainly great and encouraged, if an owner just emails their proxy or provides a photocopy, those are acceptable as well. All right, general proxies versus limited proxies. A general proxy allows the proxy holder to vote however he or she sees fit in the manner that may be undertaken at a specific membership meeting. A limited proxy, however, will list all the issues that the proxy holder may cast a vote for on behalf of the voting interest, and then it tells the proxy holder how to vote. Typically, for most issues that members will vote on, you will likely send out a limited proxy that will identify all the specific issues for the owners to vote on. And then both limited proxies and general proxies may be used to establish quorum. Okay, electronic voting. Not really going to spend a lot of time on the details of how to establish electronic voting, but what I'm talking about with electronic voting is the ability of owners to vote through some kind of electronic platform, so online, right, without necessarily having to attend the meeting physically. So to establish electronic voting only requires a board vote. So membership approval is not required to allow owners to vote electronically. It does require the board to have a meeting and adopt a resolution. And notice of that meeting has to be provided to the owners at least 14 days prior to the meeting. And you'll provide that notice either by mail, hand delivery, or can be electronically transmitted to owners who've consented to receiving notices by email. And I've included here basically some bullet points of what that board resolution has to include. This comes straight from Chapter 720 of the Florida statute, which you can read at your leisure. The part where you need owner involvement is that owners do need to opt into the electronic voting system. So while the board is the one that decides whether they want to allow electronic voting, once you have established electronic voting for your community, owners will have to opt into the system. So those that want the flexibility of voting electronically will need to consent in writing. And those that wish to vote, via the traditional method by paper ballot or proxy can continue to do so in that fashion. Okay. I've also included here some the requirements of what the electronic platform has to include or be able to do. So, certainly before the board decides to institute electronic voting for their community, I would encourage you to, get several proposals from, different vendors, compare, vet them, and then certainly make sure that the platform does what the statute requires, which are included on this page. Okay, so let's switch gears and go to elections for HOAs. So a vacancy on the board that's caused by the expiration of the director's term must be filled by election. As I previously mentioned, elections must be held at and in conjunction with your annual meeting, okay, as provided in your governing documents. And importantly, elections have to be conducted in accordance with the procedures set forth in the governing documents. So the statute has, limited provisions on, regarding HOA elections. So the statute really defers to your governing documents for conducting elections. So really, you should be conducting elections. You must conduct your elections in the manner set forth in the bylaws. Okay. Now, I know sometimes boards, boards have adopted, policies and different types of resolutions, changing their election process one way or another from what is currently provided in their bylaws. Just note that if you are following an election procedure that's not set forth in your bylaws, you subject the entire election process to a potential legal challenge. Okay. So if you do not like the way that elections are currently run under your current bylaws, then I would encourage you to get with your legal counsel and consider amending the bylaws. Okay. Now, typically, an amendment to the bylaws will require a vote of the membership. Unless otherwise provided in the governing documents, a quorum of the members must be established in order to conduct an election and any other business of the association. So for HOAs, which is a little bit different from condominiums, is that the first agenda item with any annual election meeting is that you have to establish quorum. And if you do not achieve quorum, then depending on other facts, you might be in a position where the board simply rolls over for another term. Okay. Unless otherwise provided in the governing documents, directors are elected by plurality of the votes cast by eligible voters. Candidate eligibility. All members are eligible to serve on the board unless they're otherwise disqualified. And I've included here the qualification requirements that are set forth in the statute. Okay, so for example, a person who is delinquent in the payment of any monetary obligation to the association on the date that he or she could last nominate himself or herself cannot be listed on the ballot. So they would not qualify for to serve on the board. Now, when is the last date by which the candidate can nominate himself or herself will obviously depend on your election procedure set forth in your bylaws. So, for example, if you do allow nominations from the floor based on your election procedure, then that would be the last date of nomination. So as long as that individual is, that candidate is current by the date of nominations from the floor on the date of the annual meeting, that would qualify to run. A person who has been convicted of a felony, who has not had his or her rights restored at least 5 years as of the date of which he or she seeks election, also would not qualify for the board. And then a person who has pending criminal charges for forgery of a ballot envelope or voting certificate, felony theft or embezzlement offense involving association funds or property, tampering with physical evidence, and obstruction of justice, they may also not be elected to the board. Now, nominations, which I briefly mentioned a minute ago, a member may nominate himself or herself as a candidate for the board at the meeting where the election is to be held. That's what the statute provides. However, the statute also says that if the election process set forth in your governing documents allows candidates to be nominated in advance of your annual meeting, then the association is not required to allow nominations at the meeting. So if you are one of those associations that has an election procedure in your bylaws, whether in your original bylaws or you amended it to include that nominations are not allowed from the floor on the date of the annual meeting because you have another nomination process, then you can dispense with nominations on the date of the annual meeting. A typical procedure that I've seen in lieu of nominations from the floor is, many boards like the condominium style elections, which requires 2 notices. A first notice of the annual meeting, just to let everybody know of the date, time, location of the meeting. And with that first notice, typically would include some kind of notice of intent form so that owners who want to run for the board would fill out this form and then return it within a certain time frame. Okay, so by a certain time frame, you'll have basically the nominations from anyone who wants to run for the board, and then you wouldn't allow any further nominations beyond that point. So if you've adopted a system of some sort in your bylaws, then you're not required to do nominations from the floor on the date of the annual meeting. Okay, on election day, an election is not required unless there are more candidates than there are vacancies. And if an election is not required because there are either equal number or fewer qualified candidates than vacancies exist, and if nominations from the floor are not required, then the qualified candidates will commence serving on the board at the annual meeting, regardless of whether quorum is attained. So they would be basically seated by acclamation. Now, members have the right to vote in person or by proxy unless otherwise provided in the governing documents, right? So again, how owners can vote for your election will depend on what your bylaws say. So if they allow owners to vote by proxy, they can do so. Now, if your governing documents permit voting by secret absentee ballot, then the statute does say that you're going to have to create a 2-envelope system similarly to what condominiums have. So you would have to have what the statute refers to as an inner envelope. It's a blank envelope within which the ballot would go in. So owners would cast their vote in the ballot and then insert the ballot in this just blank envelope. They will seal that envelope, and that blank envelope will then go into a second envelope, what is referred to as an outer envelope. Okay. You would include that in, you would seal that envelope, and then on the outer envelope, you'd have to have basically blank lines for the owner to sign their name and include their address. Okay. Now, unless the bylaws provide otherwise, directors will serve a 1-year term. Election challenges under the statute. Any challenge to the election process must be commenced within the 60 days after the election results are announced. So typically, election results are announced on the date of the election, right? Typically towards the end of the meeting once the votes are tabulated. So you have 60 days from the annual election meeting to bring a challenge. And then any election dispute between a member and the association has to be submitted either to binding arbitration with the division, which is the division of condominium. So the arbitration would be conducted in the manner set forth in the condominium statute, or the legal challenge can be filed in court. Those are your options and your venues. Election of officers. So members elect directors, right, through the process we just discussed, but directors elect officers. And who are your officers? Your officers are your president, your vice president, your secretary, treasurer, and then you might have other assistant, treasurers, secretaries, and so forth, if permitted in your bylaws. So generally, officers are appointed by the board immediately following the election of directors at the organizational meeting of the board. So your bylaws will typically include a provision that the board has to conduct what is referred to as an organizational meeting immediately after the annual meeting or within a certain time frame of the annual meeting. And it is at that meeting, which an organizational meeting is a meeting of the board of directors, but really the only purpose agenda for that meeting is to organize officers. You shouldn't really be conducting any other business at this particular organizational meeting. Now, directors may not vote by proxy or by secret ballot at board meetings, with the exception you can vote by secret ballot only when electing officers. So that's the one and only time that directors can vote by secret ballot. And there's no prohibition against changing officers midterm. So if, for example, the secretary is not doing a good job or the secretary wants to resign from her secretary duties, then the board has the option to, simply reorganize the officers. And you would do that at a duly noticed board meeting, and then you will just elect or appoint another individual to serve in that capacity. Fraudulent voting activities. So a person who engages in the following acts of fraudulent election voting activities commits a first-degree misdemeanor. So that includes willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear or affirm an oath of affirmation in connection with or arising out of voting activities, perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote, preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate, menacing, threatening, or using bribery or any other corruption to attempt, directly or indirectly, to influence, deceive, or deter a member when the member is voting. Giving or promising, directly or indirectly, anything of value to another member with the intent to buy their vote. However, this does not apply to any food served, which is to be consumed at an election rally or a meeting, or any item of nominal value which is used as an election advertisement, such as a campaign pin or a sticker. Using or threatening to use directly or indirectly force, violence, or intimidation, or any tactic of coercion or intimidation to induce or compel a member to vote or refrain from voting in an election. Additionally, each of the following acts also constitute a first-degree misdemeanor: knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, and then having knowledge of a fraudulent election voting activity and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Now, unless otherwise provided in the bylaws, any vacancy occurring on the board before the expiration of the term can be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitutes less than a quorum, or by the sole remaining director. So what that means is, let's say you have a board of 3 directors, 2 directors resign, now you have one single director on the board. Well, that one single director cannot really perform any function or conduct association business because there's less than a quorum on the board. And as you know, and we'll talk about in a few minutes, you need to have at least a quorum on the board in order to conduct association business. However, the one and only thing that director can do is appoint enough directors to the board to at least get a quorum. Okay, so that sole director still has the ability to fill those vacancies, at least enough to fulfill a quorum requirement. In the alternative, if there's a vacancy, the board can also hold an election to fill the vacancy, and the election will just have to be conducted in conformance with your bylaws. And then, unless otherwise provided in the bylaws, a board member appointed or elected to fill a vacancy occurring on the board before the expiration of the term will serve for the unexpired term of the seat. Okay, we're moving on to board meetings. So I guess the first question is, well, when does a gathering of the board members become a board meeting, right? Well, the statute essentially provides that meetings occur when a quorum of the board gather to conduct association business. Okay, so you need to have at least a quorum of the board in order for that gathering to constitute a board meeting. Now, board voting and decisions. Officers and directors of an association have a fiduciary responsibility to the owners, which means that they must act reasonably. Now, unless provided in the governing documents or the law, the association's powers are exercised by the board. So no one single director should be taking action on behalf of all the directors. Now, directors, as I mentioned, may not vote by proxy or by secret ballot at board meetings unless it's at an organizational meeting for purposes of electing an officer. Now, members of the board may use email as means of communication. So you can email one another. You just cannot cast a vote via email. Voting has to take place at a duly noticed board meeting. Board meeting notices. So all board meeting notices must include, similarly with membership meetings, the date, time, and place of the meeting, and must specifically identify all agenda items. Now, if you're adopting an assessment may not be levied at a board meeting unless the notice of the meeting includes a statement that assessments will be considered and the nature of the assessment. Now, in terms of noticing a board meeting, unless your bylaws provide something else, notice of most board meetings must simply be posted on your community or association property at least 48 hours before the meeting, unless there's an emergency. So take a look at your bylaws. If you have different notice requirements in your bylaws for board meetings, then you go with that. But unless you have something different in the bylaws, the statute just requires 48-hour posted notice for most board meetings. Now, the exception to that is, unless the bylaws provide otherwise, notice of a meeting at which you can adopt a special assessment or an amendment to a rule regarding parcel use, okay, those have to be noticed at least 14 days prior to the meeting, unless, again, your documents provide something else. Now, the notice will have to be, can be mailed, delivered, or can be electronically transmitted to owners who have consented to receiving notices electronically. Notice on association website. So in addition to other notice methods, association may adopt by rule a procedure for posting the board meeting notice and agenda on the association's website or a downloadable mobile application for at least the minimum period of time for which notice is also required to be physically posted in the community. So this is just an alternative way. Now, any rule adopted must also include a requirement that the association send an electronic notice to members whose email address are included in the official records in the same manner as is required for notice of meetings of the members. And then such notice must also include the hyperlink to the website or the app. And again, just a reminder, by January 1st of 2025, any association with 100 or more parcels should have already established a website or an app for posting certain documents. Now, member participation at board meetings. All meetings of the board must be open to all members with the exception of two types of meetings. So meetings between the board and their attorney with respect to proposed or pending litigation, or meetings held for the purpose of discussing personnel matters. Those are exempted, okay? So you would still post notice of those meetings, right? With the date, time, and location. You would just identify on the notice that these meetings are closed to the members because it will be conducted for either to discuss personnel matters or protected by attorney-client privilege. Now, members have the right to attend all board meetings as well as the right to speak at any board meeting with reference to any designated agenda item. The board may also adopt reasonable rules governing the frequency, the duration, and other manner of member statements, including, for example, requiring a sign-up sheet for members wishing to speak. Now, unlike with membership meetings, where they have a right to at least to speak for at least 3 minutes, there is no statutory time frame in the statute for board of directors meeting. So you may want to consider adopting a rule regarding the amount of time that that an owner can speak, which may be a minimum of at least 3 minutes. Okay, so at least 3 minutes. An owner can also tape record and videotape board meetings, but the board can also adopt reasonable rules governing the taping of the meetings. And as with membership meetings, the board meetings must be held at a location that is accessible to physically handicapped persons if it is requested by a physically handicapped individual. As a side note, directors, officers, committee members may not directly receive any salary or compensation from the association for performing their duties as a director, officer, committee member, except under the following conditions, right? So cannot be paid for your services as a director, officer unless one of these options apply. Participation by such person in a financial benefit accruing to all or significant number of members, reimbursement of out-of-pocket expenses incurred on behalf of the association, recovery of insurance proceeds, or any fee or compensation that is either authorized in the governing documents or by a vote of a majority of the voting interest, voting in person or by proxy at a meeting. And then a developer or its representative serving as a director, officer, or committee member. Okay, this is different from, contracts in which either a director enters into with the association or a director has an interest in an entity that enters into contract with the association in which there is a presumption of a conflict of interest. Now, we're not going to talk about conflict of interest in this particular class. We do offer webinars specifically on that topic if you're interested, okay? But this compensation is different from those that are under the conflict of interest. Okay, grounds for immediate removal. A director or officer charged by information or indictment with any of the following crimes must be removed from office. So forgery of a ballot envelope or voting certificate in an election, theft or embezzlement of involving association funds or property, tampering with physical evidence, destruction or refusal to timely allow inspection or copying of official records in furtherance of any crime, obstruction of justice, and then any other criminal violation under the HOA Act. The board must fill the vacancy until the end of the period of the suspension or the end of the director's term, whichever occurs first. However, if the charges are resolved without a finding of guilt or without acceptance of a plea, the director officer must be reinstated for any remainder of his or her term. And then if criminal charges are pending, then the person may not be appointed or elected to a position as an officer director of any association and may not have access to official records of any association. Another ground for immediate removal is if a director becomes delinquent in any monetary obligation owed to the association for more than 90 days. And the monetary obligation can include things like not only assessments, regular or special assessments, but can include a fine, cost, attorney's fees incurred in collection efforts or any other enforcement effort. In addition to, did I mention fines? Yes. Fines as well. Okay. Document posting requirements on the website. So notices of any board meeting, including the agenda and any document that's required for the meeting, must be posted no later than the date required for the meeting. Okay. And then for membership meetings, notices of the membership meetings have to also be posted on the website at least 14 days prior to the meeting. And then any document that is associated with the membership vote would also have to be posted on the website at least 7 days prior to the meeting. Meeting minutes. So you are required to take minutes of all meetings, membership or board meetings. And there's a lot of confusion of what minutes really should include. And I have seen minutes that are just pages and pages verbatim of what transpired at the meeting. That's not what minutes need to include. Okay, so minutes do not need to be a verbatim record of what occurred at the meeting. In fact, it could, it could potentially expose the association to liability. So, minutes really should just include the action taken by the board. So what was the vote? Who made the motion, who seconded, and then what was the ultimate vote? You may include a little bit of discussion if you feel it was pertinent to the vote, but it really shouldn't be this pages and pages of record of what was discussed. Minutes must be maintained in written form or in another form that can be converted into written form within a reasonable time. And then a vote or abstention from voting on each matter voted upon for each director present at the board meeting must also be recorded in the minutes. Okay, let's talk about the process for adopting the notice requirements for adopting a budget. So the governing documents will have to be reviewed for any specific budget meeting notice and adoption requirements because the HOA statute, Chapter 720, does not really contain any specific notice or agenda requirements for budget meetings. So these are meetings at which the board will be adopting a budget. So look at the governing documents, look at your bylaws, see what specific notice requirements exist for noticing and adopting noticing the meeting at which you're going to adopt the budget. If you don't have any specific requirements, if your bylaws are silent with regard to budget meetings, then you will simply notice this budget meeting 48 hours in advance with notice posted on community or association property. So it would be essentially no different than any other typical board meeting. Now, in terms of whether or not you have to provide owners with a copy of the proposed budget, unless your governing documents require you to provide a copy of the proposed budget, the one that you're going to be looking to adopt, there is no requirement under law to do so. You may want to consider the option of providing owners with a copy of the proposed budget so they can review it and can ask meaningful questions at the meeting. But there is no legal requirement unless your bylaws require it. Now, after you adopt the budget, once the budget has been adopted, the association must provide each owner with a copy of the budget or written notice that a copy of the budget is available and will be provided upon request. Now, if an owner does request a copy of the budget, then the copy of the budget must be provided to the member within the time frame set forth for inspection of association records, which means within 10 business days after receiving the request. And then just a reminder that by January 1st of 2025, the associations with 100 or more parcels have to also post a copy of the annual budget on their website or the app. All right, notice requirements with regard to adopting a special assessment. So written notice of any board meeting at which a special assessment will be considered must be mailed, delivered, or electronically transmitted to the member and posted conspicuously at least 14 days before the meeting. Unless, of course, your bylaws provide for a longer period, in which case you would provide the longer period notice. Now, the statute does require that the notice of the meeting must include a statement that the special assessment will be considered and the nature of the assessment, and should also identify the estimated cost of the assessment. Now, once you formally adopt the special assessment at the meeting, the association should send written notice to the owners, letting them know that the special assessment has been adopted, and then allow owners within a reasonable period to pay the special assessment. A special assessment that has not been paid by an owner can also be collected in the same manner as any other regular assessment through the lien foreclosure process. For committees, just note that the same meeting notice requirements apply for meetings of any committee when a final decision will be made regarding expenditures or association funds, or any committee having the power to approve or disapprove architectural decisions with respect to a member's lot. So all those ARC committees that you may have formed, notice requirements do apply to these ARC meetings, right? So they have to be duly noticed at least 48 hours in advance. Now, fining and suspension of use rights. I'm not going to be discussing in this webinar the specifics of how you adopt a fine or suspend use rights. I'm only going to bring up the notice requirements associated with this process. So, as you may be aware, associations have the right to either fine owners or suspend their use rights to common facilities, such as, your pool, your tennis courts, your gym, if you have access, if you have the ability to control access to these abilities. And you can suspend and fine if owners or their tenants, guests, or invitees have violated either the governing documents or association rules. Okay, so these are some alternative remedies that boards have for covenant enforcement. Note that if you're going to fine or suspend use rights for covenant or rule violations, there are some notice requirements. So typically it is a two-step process, with the first step being that the board has to adopt the fine or the suspension. And the meeting at which you can adopt that fine or suspension has to be duly noticed in the manner that we've just discussed, right? At least 48-hour notice, unless your documents provide for a greater time period. Now, once the board has adopted that fine or suspension, the second step to this is that fine or suspension cannot go into effect unless the violator has gone before a committee, right, and has had their committee hearing uh, to um, to contest the fine or suspension. Now, notice of that committee hearing has to be provided at least 14 days prior to the committee hearing. Okay, so there's your second notice. Notice of the committee hearing has to be either mailed, hand delivered, or can also be electronically transmitted to those, if the violator has consented to receiving notices electronically at least 14 days prior to the committee hearing. Okay. We do discuss finding and suspension of use rights in more detail in our covenant enforcement class. So if you're interested in learning more about that process, or what other remedies you might have for enforcement, then I encourage you to take a look at our website and see when that webinar or seminar is offered next. Now, the committee hearing has to be held also within 90 days after issuance of the hearing notice before a committee of at least members who are appointed by the board and are not officers, directors, employees of the association, or spouse, parent, child, sibling of the officer, director, or employee. And then the last notice is that within 7 days after the hearing, the committee must mail or email written notice to the violating party of the committee's findings related to the violation, including if any applicable fines were confirmed by the committee. Associations also have the right to suspend use rights to common facilities if the owner is delinquent on any monetary obligation owed to the association for more than 90 days. Okay. Now, if you're going to suspend use rights due to a delinquency, that is a board action that the board can take at a properly noticed board meeting without the committee hearing. Okay, you would simply notice that board meeting at which you're going to suspend use rights for this purpose at least 48 hours in advance. For the suspension to take effect, you'll have to provide written notice of the suspension, which has to be mailed, hand-delivered, or emailed to the owner, and if applicable, to the occupant, licensee, or invitee. And then the suspension for delinquency will end once the owner has made full payment of the delinquency and brought their account current. Voting suspension. Association boards have the ability to suspend the voting rights of an owner if the owner, again, is more than 90 days delinquent on a monetary obligation owed to the association. And again, similarly with suspension of use rights due to delinquency, board can do so by board action at a duly noticed board meeting without having without the requirement of the committee hearing. Let's see. Oh, well, that's the end of that. So that was our last slide.
Well
Let me
done.
stop sharing.
And
right.
I'd already placed the link for the post-webinar form into the chat. So if anybody on this call has not yet pressed the chat button so the chat area appears, please do so now. And I'll place the link for the required post-webinar form in there once again. Kirsten is looking over a handful of the questions. She's going to answer a few of the Q&A. There's a ton of them, but we're only going to get to a few of them. And before she does, I want to mention something that's coming up quite often in the Q&A here. And that is, what happens if I'm a board member and I don't have my 4 or 8 CEUs done by the 30th? And I'm going to go back to remember, I'm not the attorney here, but this is what I have in writing from the division, is that anything you take post June 30th will apply towards whatever is deficient currently. But then you must still go back and take the 4 or 8 that you need on that next cycle, which is July 1 to next June 30th. So I hope that makes sense. So just like with CAMs who are deficient, they got to take their deficiencies and then continue with the new cycle. Same thing for board members. And then the question that's now come up here 4 different times, which I was typing when Kirsten finished. That's what caught me off guard. I was answering this question. Um, Truthfully, there's not much of a way to enforce it right now. We provide the certificates to you guys. You file them wherever your official records are filed. We don't send anything to the state. No provider sends anything to the state as it stands right now, except for manager certificates, reporting managers. So the only way a board member can get called on this is if you are deficient and somebody challenges you, wants to see the records, and they see deficiencies in your education. So my advice is if you're deficient beyond June 30th, take them as early as you can to get caught up and then continue with the next cycle and file them. So I'm going to place the link for the evaluation in the chat once again while Courtney and Kirsten look over a handful of the questions. And then afterwards, I'll remain on to help with the technical aspects of the post-webinar form. If you don't want to stay for the Q&A, it's not required. Your requirement ended after Kirsten completed her final slide and you submit the online form. After that, you can go if you need to. Kirsten, back to you, my friend, as well as you, Courtney.
Okay.
And that was a mouthful. Hope I didn't confuse anybody even further.
All right. Let me take a look at some of these questions. All right. Can board members be replaced during a special membership meeting? There is a process by which directors can be recalled, and one of them is by membership meeting. There are requirements for how you petition for that meeting, and so presuming that that meeting was properly petitioned and noticed and conducted, conceivably, yes, directors can be removed at the meeting, and then replacement of directors will depend on how many directors are ultimately recalled. So it's a little bit of a complicated process and a little bit beyond the scope of this this class. So I'll just leave it at that. Can the members at a special meeting called by the members overturn a previous board vote regarding any matter? That's not how it works. Typically, members can only vote on things that members are allowed to vote. So they don't typically overturn decisions of the board unless there's specific authority for members to do so. Let's see. Who conducts a member special meeting since the board is considered part of the membership? I know that's confusing because directors do, they wear multiple hats, right? They wear the hat of the owner and then they wear the hat of a director. But typically, membership meetings are still conducted by the board, right? So the board still notices them, the board still takes minutes. So the board presides over these meetings. Let's see here.
For anybody asking questions about education requirements, let Kirsten finish the Q&A. When she's done, she'll let us know. Then I'll stay on and answer any questions about your education requirements.
Okay. In your example of 100 homes, if only 20 people show up, we can't have the meeting or elect board members. Well, that will depend on what the quorum requirement is, right? So if the bylaws provide for a quorum of 30%, which is what the statute provides, then yeah, you would be able to establish quorum or conduct business. But if your quorum is less than 30%, then you might, depending on the quorum requirement. Let's see here.
Again, folks, if you haven't pressed the chat button, That is where we place the link for the required post-webinar form. The Q&A module and the chat module are two different things. Course questions into the Q&A, technical questions, and the link for the evaluation will be into the chat.
Okay. Can proxies be defaulted to the board if not assigned? So I think the question is if the if you don't identify who the proxy is on the actual proxy form, can that default to the board? Yes, it can default to one of the officers of the board, depending on how the proxy is drafted. Let's see here. The 8-year maximum service term applicable to HOA boards. No, that's a condominium concept. Let's see here. Let's see. We have a 3-person's board. If I talk to my next door neighbor who is also a board member about the community, is that considered a meeting? No, I would not consider that a meeting. Similarly, if you happen to be by the pool and another director comes and joins you and you're sitting together, and talking about the community, that will also not likely be considered an official board meeting. When the board is going to approve the annual operating budget and change dues, does the board meeting need to be noticed for this? Absolutely. So you would need to notice a board meeting, right, to adopt the budget and change your assessment amounts. Can board members attend board meetings of other associations on their community? Typically board meetings are reserved for owners. So if these board members are owners or considered members of these other associations, the answer would be yes. Otherwise, it would be, by invitation or unless the other boards don't object. Let's see. Let me take some from towards the end. Do ARC decisions have to be made at a meeting? Yes, ARC committee meetings are one of those that are required under the statute to follow the same notice requirements for board meetings. Let's see here. How should an owner being considered for a fine be listed on the agenda? I wouldn't necessarily identify by name, perhaps by parcel number. That's probably the better option.
Folks, again, I'm starting to get concerned that folks are not listening to our instructions, which is very, very important because the deadline's a couple of days away. I'm still getting, after repeating this a half a dozen times already, about the how do I get credit for today in the chat area where you're asking me these questions. That's where we place the link for the required post-webinar form that we placed in there several times already. So click on that link, fill it out, submit it. That's the information we use to send you your certificates and get managers their credit as well. Kirsten, back to you.
All right, I'm going to answer the last question. Is there a minimum time required between adjourning member meeting and reconvening to obtain a quorum? There's no minimum time requirement in the law. You'd certainly want to look at your bylaws, but the important thing is that you want to make sure that the minutes of your meeting reflect the new date and time of the reconvened meeting, right? And remember, you're still limited to the 90-day window. Okay, that's all the time I have for today.
Well done, Kirsten, as usual.
Thank you,
All right.
Kristen.
Thanks, everyone.
You have a wonderful rest of your day.